Belinda, do you want to explain about the segments? Okay.
Sure. I'm Belinda, and I'll be acting as the moderator just to keep us on task today. And we have broken today's brown bag up into 3 sections or segments. The first segment will spend about 40 minutes for introductions and comments from each panel member. So each member will have approximately 10 minutes each to introduce themselves and to talk about the question that is at hand, their transition from an attorney into mediator. The second segment, the panelists will have 10 minutes total to respond to each other or to comment based on other panelists' comments, if that makes sense. And then we'll open it up in a third segment for open discussion for all of us to ask questions and to give comments about the topic. And reintroduce your questions.
I'm glad you're sitting next to me. You can poke me more easily.
So if we're ready to get started, we're ready, Jermaine? Yeah, okay. So should I start with Tom?
I think we were going to go alphabetically, right?
Alphabetically by first name. No,
by
alphabetically
last name.
by last name. So we sat you in
Okay.
order.
I was going to say I need to remember your names. Your last names. Tom, we'll start with you.
Good. First a question. Are you going to hold up a card and say how much time we have? Or are you going to make some signal?
Yeah, so I think everybody is getting around 10 minutes, so at least you know what your time frame is. And then I've got a 3-minute,
Oh, great.
and a
Great.
1 minute,
You've-
and then done.
You've answered that.
And Sally made it, by the way.
Well, I'm Tom Brush, and I want to say that this is how this is developing. Reminds me of one of my first campaigns when I was running for public office in Cincinnati, and it was in the basement of a church down in an old little part of town, and we as candidates were just so anxious to find people that we could talk to and get the word out. And we were, this was one of my first campaigns, I think. And I think there are about as many people in that audience as there are here. And so each of us, there were 9 seats available, and I think there were about 22 candidates. So the candidates were all there, and they were really pouring their hearts out as to how, what they would do for the city. And I think I was one of the last ones to speak. By the way, one of the people who spoke was Jerry Springer, because he was running for city council. So if any of you know Jerry Springer, you know that he was a rather dramatic kind of guy, and he was very entertaining. So it was my turn to speak, and I thought, I'm just kind of curious. Of you 4 people here, how many are registered voters? There were no registered voters there. But there was one dog. Seriously, there was a dog in there. So I thought, I got used to this, by the way, going around the city, talking to crowds of people, and having kind of blank looks on their faces, and then finding out that they didn't know why they were there. They thought that they were there, because there's free coffee and donuts. And so, welcome. I'm looking forward to it. I've become a believer in we all are products of all of our experiences in life. Whatever we're doing, we bring these experiences, whether they're conscious or not, to the situation. And so my experience has been kind of varied. After I graduated from law school, it was a time when the draft was on, and if they were going to grab you and draft you immediately as soon as you walked off that stage. So I decided I would join. I would not wait for them to take me. So I came home one day and told Sally I just joined the Marine Corps. And that's where I spent the better part of the next 6 years. It was a pretty wild experience, but I'll just describe one that I think has something to do with this subject. We were we had very few places to train. This is over in Southeast Asia, because we were on a little island. And so we went, we'd go up to Japan and train up there. There's some beautiful places up there at the base of Mount Fuji. And when we arrived, our flotilla of ships, I noticed that on the shore there were lots of banners, and of course a language I couldn't understand, and people that looked pretty agitated. And so we went ashore and we set up our camp, and it turned out what had happened is that the Japanese government had told the farmers that they would be paid for the use of their land. They never got around to paying the farmers. And so the farmers saw us coming, and they were mad. They really were mad. So you've got a bunch of Marines, and you've got tanks, and you've got all sorts of equipment. And one day, the commanding officer came in to see me, and he said, "Brush, Lieutenant Brush, we've got a problem. I want you to go solve it." Now, he knew I had gone to law school, and so I think he thought that if I'd gone to law school, now she must be really capable of dealing with these kind of crises. So the only problem is I did not speak Japanese. So we went out, and I found a person that spoke English and Japanese, and I said, "I'm going to need all of your help here." So he said, "Fine, well, So we went out in this, it was kind of a field, and all the farmers came in, and we sat down in a circle on the ground. And the translator explained who I was and why I was there. And with that, there was just talking, everybody's talking at the same time, and lots of gesturing. And so I just said, what I'm going to have to do is just see if I can figure out what's going on. And by the way, this is a pretty good experience to have when you can't speak the language, so you shut up and you just listen and you watch and try to gather as much as you can from that kind of experience. Well, it was pretty easy to understand actually what they were talking about is that we had run some Marines had run some vehicles through some rice paddies, and they had destroyed a number of rice paddies. So not only were the farmers not being paid, we came in and kind of tore things up for them. So I told them I had no authority for this, that I would take care of them. I would see to it that their paddies were restored. And the translator told them about that, and everyone seemed to be very happy. So I went back into camp and got some Marines and trucks and some equipment, and we went out and we repaired all the rice paddies. Well, now the commanding officer thinks I'm a miracle worker, that you can go out and do this. And it wasn't anything, I'd said hardly anything, but I just listened to them and understood their problem. And I think one of the things they were happy about is they said somebody is listening to us, even though I was listening but really couldn't understand everything that they were saying. When I got out of the Marine Corps, I came back to Cincinnati and started the practice of law. And most of my work was in litigation. So I was in the court a lot. And one of the things that struck me is this is a pretty archaic system for solving problems. Look at all the people we have in this room. We've got a judge, we've got a bailiff, we've got a clerk, we've got a stenographer, and this whole cast of characters just to try to solve this problem. I found that it takes a long time to solve problems that way, and it's very costly. So after some years of working on these kind of cases, I decided that there must be a better way. Sally had been doing some work in divorce, working with families in divorce. And someone decided, and by the way, the state of Ohio changed the laws concerning divorce where you could get a dissolution of your marriage rather than what we call a straight divorce. The straight divorce, you've got to file a lawsuit, accuse the other party of violating the marriage contract. Usually had to be certain things like adultery, non-support, gross neglect of duty. So people, when they came in, were already, the system put them at loggerheads. So the no-fault divorce caught on, but no-fault divorce meant that the attorneys would have to help parties negotiate things like a parenting plan. And the attorney says, we don't know anything about that. We don't know anything about parenting. We're lawyers. And so we started a training, and one of the trainings, a person by the name of Zena Zumeda came in to give a course in mediation. I went to that course, and during that course I felt, this will never work. I don't know why this would work. Parties they're already disagreeing, and you're going to talk to them about listening and things like that. I don't think this will work. Well, Zena Zumeda finally told me, shut up, and don't ask any more questions. And so I learned, just listen. So I started practice. I started doing mediations and found it personally much more satisfying than being an attorney. And because I felt actually that attorneys were in many cases, this is my experience, perpetuating the conflict. And some attorneys actually get a reason for that. And that is, the more time they spend on the case, they're finished. Okay.
You can finish your sentence.
You get to finish the sentence.
You said the more time they spend on the case.
Oh, yeah, they charge by the hour. And most attorneys did, no matter what the result.
Thank you, Tom. You're all set? I'm good. Okay.
I'm going to be quiet.
Okay.
I didn't know that.
Thank-
about Tom.
Yeah, that's an interesting tour. Every time I hear the brushes speak, I learn some new factoid about them. Now I know you were in the rice paddies. Well, continue.
So
Juliet?
I don't have as many cool and interesting stories here, but I'm Juliet Pressel. I've been an attorney now for almost 27 years. I'm old enough so that it was kind of like a second career sort of thing. I worked in hospitals predominantly before that, mostly university hospital, mostly in unit management services and administration. So this was a career change for me. But I was interested in mediation for way farther back than that. I graduated at the end of 1991 from law school, but I'd been interested in mediation ever since Jimmy Carter and his Camp David Accords brought peace to the Near East, at least between Israel and Egypt, in a totally shocking and unanticipated turn of events. And it was a lasting peace. So it was very clear to me that that was momentous and something to be desired, because I'd never seen anything like that. I was not interested in law because I pretty much regarded lawyers as contentious people who were advancing their own causes and lived off basically other people's misery. And so when I wound up going to law school instead, it was a much later decision in my life. I looked around to see what sort of training in mediation there might be in law school, and there was none. There was one course being taught there called Negotiation by the esteemed J.J. White, who had been a Marine, and his view of, the term mediation was never used to my knowledge, but his concept of negotiation is the last man standing wins. So that was the person who got the A+, and everybody else got diminishing grades, depending on, I never took this class, but this is what I heard, how soon you got outplayed was, that was a good reason not to take class right there, because I knew I was not going to be the last man standing. I'm really happy today that mediation is an option. In fact, it may even be a required course in a lot of law schools, and in the firm that I am still on the letterhead of, Bassett Law, one of my associates there is, she took mediation in law school, and it's a wonderful thing. So the culture's changed. But of the 27 years that I've been a lawyer, about half of them were spent working for judges. So you are not necessarily an advocate when you are serving as a lawyer. And I actually preferred working for the judges because they were the people who are tasked with resolving disputes. And yes, it is an expensive process and an extensive process, and it wears people out. And that's actually sometimes, actually most of the time, why they settle, is that, you know, they're just hemorrhaging. They're hemorrhaging money and they're hemorrhaging sweat. You know, they just want to go on with their lives. So being an advocate is not necessarily something that you have to set aside when you are a mediator, because it isn't necessarily part of the picture to begin with. But I've been trained as a mediator since 2002, so I had been an attorney for 10 years when I finally had the opportunity to get trained as a mediator, and I was not trained by Zena. I was trained in civil mediation in 2002 by two people who had trained with Zena, and then in 2003 I was trained in domestic relations by Zena, and then much later in 2013 probate training by Zena, and now I do special ed mediation, and Zena hasn't had anything to do with it, but she really deserves the honor because she has kind of been the mother of mediation training in Michigan, and she's the person who caught the ear of the Supreme Court, and thank God for her. So I've mediated privately. I don't like it as much as mediating for free, but it's important to understand that when you're mediating for free, there's one less person in the room who's charging money. And it does make a difference when you're in the room with people whose cost to be there is maybe that they are not getting paid for the time that they're away from work, or maybe if they're self-employed, that's time burning away. So I am conscious all the time about what it's costing people to be there, even if my services are free. But there's no question that when you add lawyers to the mix, they're interested in efficiency, their clients are interested in efficiency, and sometimes it does change. The mode does change from purely facilitative to more evaluative, especially because as a lawyer you might very well understand the issues. I would say it's not difficult to shut off the urge to dispense legal advice. It isn't useful for attorneys to be spouting legal advice in all circumstances. For 10 of the years that I was working for a judge, I worked for a local judge, Judge Nancy Francis, now known as Nancy Wheeler. And she was one of the people who set out to change the culture in the family law court. And she was the one who imposed the first standing order for mediation among divorce litigants. And she would have loved the option of a dissolution rather than what you're talking about is divorce for cause. And we have no fault divorce, but still, you still have to file, somebody has to file a complaint, somebody has to file an answer. And Judge Francis did not want the first to the courthouse to win, which is kind of how it was set up. You know, an attorney would file a case on behalf of a client, and they would get all these ex parte orders, and before the other person was even on notice that a divorce complaint was filed, there were all these orders saying, you know, first person to the court gets everything he or she asks for, and the judge says this is untenable. And so she was the one who imposed that standing order for mediation, and so my training in mediation came in really handy because I was kind of the person telling people, okay, this is what the judge wants, these are the people that you can go to, here's what you need to do, and I was authorized to give legal advice by her to whoever came, so that was easy, but you aren't, you know, it isn't necessary to do it all the time. So I'm kind of bouncing around here, but I think that mediation it takes us back to the early days when in groups of people who actually knew each other. You know, you have disputes, you have falling out, and then you go in front of the elders at the gate, you know, and you'd hash it out in front of them, and they would think about it, and they'd help you resolve it, or if they couldn't help you resolve it, then they'd make a ruling. One of the freedoms that I have as a mediator for the Dispute Resolution Center, which I've done now for about 6 years, and so have you, so it's not 5, it's more than 5, is that if I can't get people to settle, that's okay, that's what judges are for. And sometimes you preside over, so to speak, you preside over a settlement that you kind of wish they hadn't settled, because I know as a lawyer what the outcome would probably be. Not always, but sometimes. But it's just so much more efficient and cost efficient, and people can go home and say, I'm done with it. I can be done with it now. I don't know that there's anything else I need to add, but
That's okay. Yeah. And I will add to Juliet's modesty that when Judge Francis decided to sign the order or to do the legal part of it for divorce cases, it was a big deal throughout the state, and it just sort of swept through the state of Michigan. So Washtenaw County is on record as being that progressive in the field of mediation. So we're always thankful to her bravery for doing that.
And I should add that after she did that, every one of the other judges who did family law cases, every one except one of them, signed on and adopted
did the same
that policy.
thing, yep.
And oddly enough, the judge who did not sign on was Judge Brown, who is now in charge of the business law court, and he's the one who has to do ensure facilitation in business law cases.
Yep.
Karmic.
Yep, so really thankful for her being brave.
Yes.
Your turn, Phil.
My name is Phillip Schaedler. I'm a recovering attorney. I still practice law, but initially my practice was rather different, perhaps, than most of the other attorneys here. Well, it started in a traditional way, and I was trained to be the zealous advocate. One of the first things the dean of the law school where I started said to us as first-year students was that we must never forget our responsibility as counselors first, and attorneys second, that we had a responsibility to our clients to see if there was a way to restore peace. That said, we promptly went on to be trained as the zealous advocates and the bulldogs and the street fighters that we all thought lawyers ought to be. And that lasted until I got my first real job, which, as it turned out, was as vice president of medical affairs at a hospital, which is a fancy title for the risk manager, if you're familiar. And what we learned there was that the medical staff had a very definite idea about what our position ought to be, and the nursing staff and the administration. The patients had a very definite idea about what the risk manager's job was and what his or her position ought to be. And certainly the plaintiff's bar had a very definite position about what your responsibility was and what your position was as related to them. Probably the most important advice I ever received in that initial stage was from the vice president of medical affairs, who looked then like I look now, which is to say he had mostly white hair and wrinkles, and he was a wizened old fellow and kind of knew his way around. And he said, you have to understand in your job that it's all about your relationships with the medical staff and the nursing staff and the administration, and it's all about your relationship with the patients, and it's all about your relationship with the attorneys that represent these people, and the most important relationship that you have in this equation is that relationship with the patients, and the thing that you need to be mindful of is that they are not at their best. In many respects, they're at their absolute worst. They're sick, they're in pain, they're anxious, their families are worried about them, they're in a strange, cold, sterile place that isn't what you'd call real hospitable or inviting. They don't understand the lingo that's being thrown around, and all they can do is sit back and watch. So you have to be, in many respects, their eyes and ears, keeping in mind that your responsibility is to the facility. You're the risk manager. You're not there for them. And that seemed to be, it was great advice, but it seemed to leave a vacuum. And that vacuum, I think, was magnified by the fact that the way we had to respond to concerns or grievances of patients was this traditional litigation, this adversarial process. And it occurred to me after I'd been there not very long that this was extraordinarily expensive. It was extraordinarily disruptive and destructive. And by that I mean the process was so bitter that we would have these highly trained, enormously experienced personnel say, frankly, the hell with it. I'm out of here. You can have this, where I'm leaving here. And that was a resource that we couldn't afford to lose. And it was reflected in the attitudes of physicians who didn't trust their patients. And that impacted the way they practiced. It was reflected in the attitudes of administrators and, the way that, and their relationship with the caregivers. These plaintiffs' lawyers in particular were ruthless, thought nothing of coming in and disrupting your daily routines in the facility and embarrassing your personnel and browbeating them to the extent that they felt like they had somehow weren't worthy of their profession, so they would quit. As Tom said, and had lots of people, the carrying costs of that process were enormous, way more than they should have been. And more importantly, when your patients and their families left your facility, they had nothing good to say about you. No matter what good you might have done while they were there, the slight that they felt was the thing that they talked to their friends and the community about. And when you put it in the context of transactional costs, you can't afford that. You can't have that. You can't have people leaving the facility dissatisfied with the experience. So the response to that, and this was I've been an attorney for 36 years, so this was back in 1984, more or less. We implemented a system of what we called then care conferences. Now they call them root cause analysis. They call them mediation. They call them lots of different things. And that's kind of what led me. So I've been doing this, whether as a trained mediator or not, for 33 years. My training I got from Xena. After that was to satisfy the requirements of the state of Michigan, but I had been by that time a member of the American Association of Healthcare Attorneys and a trained arbitrator for them. I had been to Harvard University to the dispute resolution course there. I was sent there. I had actually left healthcare and went to work for an insurance company as a claims manager. I should tell you that these claims weren't your average slip and fall. They were multi-million-dollar international business claims. So there was lots of money involved. And I was involved as an advocate in those mediations. So I saw that commercial side. I in my own practice have done, I think, a fair number of domestic relations cases. I'm trained as a restorative facilitator. I'm trained as a circle keeper. I'm trained in the USDA agricultural mediation process, which is somewhat different because it's so regimented. And my attitude about this is that much like Tom and Juliet said, there's a better way of doing this. It's cheaper, it's better, it's faster, it's confidential, it's more satisfactory because it's a product of the imagination and creativity of the people who are most impacted by a conflict. That is, those are who are involved in it. The only way, nobody likes, my attitude about it is nobody likes to be told what to do, but they're almost always willing to try to find a way that they can both live with if they're given the opportunity. It's that pause from the traditional process that allows them to talk with one another instead of to one another, if you know what I mean, and consider what their needs and interests are. And I know that sounds trite, but it really is true. That's what you're asking them to do. And that's how I got where I am. I'm almost fully recovered. One more year, and then I'll be fully recovered.
Thank you, Phil. And I'll just add that Phil is also involved with the Dispute Resolution Center south of us that covers Monroe, Lenawee, Jackson, and Hillsdale, right?
Well,
Buddy
I
Martin.
volunteer for you too.
Yeah, as well as our center as well. So thank you for being so spreaded with the CDRP program. We'll now go to Betty.
All right. So I'm Betty Widgeon, and glad to be here with you guys today. I came to do what I'm doing right now, which is full-time ADR practice, in somewhat of a circular path. I started out, I graduated from law school in 1980, so I've been an attorney for 39 years. The only ADR class that was offered at Michigan when I was in law school was a lawyer as a negotiator. I really loved the class. It was taught by Judge Harry Edwards, and he was there for just a few years, so it was a lot of fun. But I didn't have any other classes that had to do with ADR, so I didn't really know very much about it at all. I knew that I liked that class. What I didn't like about it, it was winner take all. So, and I had one partner, the last negotiation that we did, and he just was so stubborn, and he caused us to be bumped from the top spot to the second spot, and I didn't like that. But I still remember him, and if I see him at any kind of reunions, I'll have to ask him about that. At any rate, so I never really saw myself as a litigator or as a practicing attorney. It was something that I was interested in doing, going to law school, because I wanted to know what else I could do with a law degree. I did not grow up in a family that had ties with lawyers or relatives or anyone in my immediate or distant background that knew anything about or that who had been a lawyer. So for me, that was it was something new. And I decided to apply to law school after I finished undergraduate school at Wake Forest down in North Carolina, and after I had completed a master's degree in counseling, because that was an interest that I had. I saw myself as a counselor. I had always been a person who would listen to both sides, but I didn't stick to one particular clique. I found that out from high school and on. That's just what my makeup was. At any rate, I did go to law school, and I started out as an intern with the Legal Services of Southeast Michigan for about a year, right after I finished law school. And then I decided that I wanted to do something else. So I worked with the University of Michigan on a project that was called the Race and Sex Equity Project. I think it may have had a different name, but it was headed up by Dr. Charles Moody, and I was one of the associates there. I worked to help the state of Wisconsin come into compliance with the Race and Sex Equity requirements that they had for their public schools that they were under court order to do. So that was pretty satisfying. I enjoyed doing that, and I did it for a couple of years. And then I said, well, let me try this practice of law again. So I went to the UAWGM Legal Services Plan. I think I was there for 4 or 5 years. I taught at Eastern Michigan University part-time as a business law assistant professor. I even taught some classes in the prison at what was called Jackson Prison, or the state prison for Southern Michigan in Jackson. And then I went back to law practice for a couple of years. So I kept going in and out of law practice, trying to see if that was really me, but it never did seem to catch on. And that wasn't unusual for me, because it didn't seem that strange to me, because I knew that that was not what I went to school for initially. But I decided at one point that I wanted to become more comfortable and familiar with being in the courtroom. I didn't want to be intimidated by being in there and working with the judges and going up against other attorneys. As long as I was going to be an attorney, I wanted to be comfortable with it. So I applied for a position at the prosecutor's office here in Washtenaw County, and I got that position, and I got thrown into court every day and every week with 30 to 40 files, and you had to be ready for that, and you had to be ready for the bench trials and for the jury trials, and that was a really good experience for me. But I actually had only been in the prosecutor's office for less than a year when the judge that I was appearing in front of every day, or at least several times a week, announced in no uncertain terms that he was not going to be there past January, so we might as well not try to adjourn any cases to beyond that, because he was going to have pretty much everything done before he left. And I and 15 other attorneys applied to the governor's office at that time for the appointment to finish out his position. I was selected for that, and almost immediately I had to run for my election in the fall. And learning a new job and running for an election and going to breakfast meetings and figuring out what campaigning was all about, that was a handful. But I had friends and family who came to support me and won the election in the fall. So I did enjoy the time that I spent on the bench, but it was toward the end of that first year that I realized this is not something that I want to do forever. While I like being a neutral, I need more flexibility. I'm the type person who I can work on projects and enjoy those and give it all that I have, and then I might want to change up. I want to do something else maybe a little different. So I started thinking about mediation and arbitration. I really thought about arbitration first because I thought that was the easiest or easier transition from the bench than into mediation would. I remember I had taken at least 2 of Zena's mediation, 40-hour mediation courses by the time I left the bench. I remember one of the courses that I was getting ready to take, and I had contacted Sally or somebody at the Dispute Resolution Center, and Sally said, well, judges are some of the hardest ones to train. And with that encouragement, I continued to go down that path. And I did find mediation to be satisfying because of how it actually worked. Sometimes I found it a lot more difficult than arbitration. Well, you know why? Because as the arbitrator, they do the hard work of presenting their cases and evidence to me, and then I do the work that sometimes is hard work and sometimes is not that hard, depending on what the topics are, of making a final decision. But at any rate, that was my path from where I started out to coming into alternative dispute resolution. Like everybody else here has said, I was sold on the idea that you could do something aside from going to court, something that was quicker, something that was less formal. I'm all for informality. If you can get the job done and people don't have to be intimidated about what's happening. So As to a couple of the questions that were raised, how do you resist getting into the legal, someone raised that question, I think. Was that you, Craig? I think.
Yeah.
How do you resist getting into all of the legalities? And also, Shannon, I think you raised the question of your role as an advocate. How do you separate yourself from that? As far as resisting getting into the legalities, I see that as something that is helpful for both the people who are in front of me and also especially for the mediator, because we explain clearly that we are not there to be an attorney for either side, and that we cannot really tell them what will happen in court. So I don't try to do that. It's not that difficult for me to stay away from that. It's written down in the agreement that they go over in the beginning, and since I never was one who felt that I needed to jump in there and be the litigator from the beginning, I don't have any difficulty with that. I don't believe that I do anyway. As far as the role as an advocate, as I've said, I generally see myself as either a counselor, consultant, someone who can listen and then give some remarks, but not as somebody who is going to advocate one position or the other. When I'm doing arbitrations, I'm still not going to get out there as the advocate. And though I might have a couple of questions to ask, I try to keep those as a minimum and let the attorneys do their job. So that's just something that's been very satisfying for me, and I haven't had a lot of difficulty with it. That's it.
Thank you. Thank you. And I'm going to also add that Betty has been a past board member of the DRC and has been connected with us for quite a while. Yeah, for quite a while.
And I want to say that I had just had to fire a judge when Betty came up to me.
I didn't know that.
Who was unable to get himself out of that role. And he finally, after an hour of my telling him I thought he might have been a very good judge, but he wasn't able to translate to a new career, he said, well, I think I'll continue to mediate anyway. And I said, not our center. I thought he had to be that direct with him. So, and since then, I do say it's hard for judges to unlearn, but I never say it's impossible, because I think Betty is one of the most talented mediators we have. Has been from the beginning.
Yes, absolutely. So that concludes the first part of today's brown bag. But before the second part is to give the panelists an opportunity to talk to each other, follow-up questions, comments about anything that you've heard from each other, or anything you want to complete in your thought and comments. This is a good opportunity to do that.
I just had a question for Judge. Are you still called the judge a lot?
You know, it's very nice to have that title, but I don't usually need it. If I need it, sometimes with arbitration and some attorneys who act as attorneys do, it's nice to have that title because it helps them see that I'm in charge. But no, it's there, and I'm glad it's there.
It seems to be a title
but
that you will have for the rest of your life, whether you're on the bench or not.
I figure that's from the hard work of going through law
Yes.
school for 3 years and the other. I had a question for panel members having to do with mediation and doing co-mediation. Mm-hmm. Do you find that you would rather do solo mediation, or is there something about co-mediation that you find also very helpful? Because I've got an answer to that too for myself. But
Well, I was trained to do co-mediation, and I think after I had done it for quite some time, I convinced myself that I do a better job by myself. I've kind of rethought that. I enjoy working, and it depends to a very large extent on the nature of the case, but I enjoy working with other folks who have different perspectives, and I appreciate having the benefit of their imagination and their creativity and their ability to deal with the needs and interests of the parties. So I still like to do particularly in commercial mediation, but in domestic relations, I value the opportunity to co-mediate.
How about the other two?
No, back up a bit so you can see
I
each other.
find it's if I know the other mediator and had the time to kind of get to know them, even if I don't know them personally, get to know them ahead of time, because it's it's like a dance. You know, either you move well together or you step on each other's toes. And I think I find it very helpful in where there's a lot of facts going on, or people, I've had mediation, especially divorce mediations, where boy, the people are just going lickety
Tooth and
split.
nail.
And since we don't take notes as mediators, I like to have somebody else to stop and say, what did you hear? Because this is what I heard, yeah. So I think I would prefer it if we work well together.
Well, obviously I've done it both ways, and I think I would say, like Phil, it kind of depends on really the complexity of the case, how many people are going to be sitting at the table. I know that in probate mediation, where you can have a cast of thousands, Zena pretty much says out loud, you know, you're really much better off having a co-mediator, bearing in mind again that if you are a private mediator, which I've been, if you're going to have co-mediators, you're either going to be choosing to accept half your ordinary pay, or you're expecting the parties to pay you twice what it would cost otherwise. So there's always a price issue in there, but when you take that off the table and you just talk about when my services are free and my co-mediator's services are free, you know, if it's not that complex a case, probably don't need a co-mediator. You may not need a co-mediator in a complex case, but it's so much nicer to have somebody to bounce things off of. And you know, I'm happy to be praised as brilliant, but everybody's got their limitations. And it is, I enjoy having a co-mediator because there's always somebody to act as a check and balance. And when I have run out of steam, and sometimes I run out of steam, you know, I have co-mediated with a number of people in this room, and it's always been a positive experience. So I think it just help us along. I will say, yes, there are some people who are harder to co-mediate with than others. It's at times like that that I feel that they're very fortunate to have me. Because I have co-mediated with some people, not too many, who said some pretty scary stuff. And I can kind of apply the brakes and say, no, what we mean is. So that checks and balance, but it works in both directions. You know, I find it, I like it. And in special ed mediations,
Yeah.
I really like it, especially because you can have a boatload of people from the school system, and they're all authorities, right? They've all got their degrees and their vast years of experience, and then you've got the parent or parents and maybe an advocate over on this end, and you know, they're holding on by their fingernails. It's good to have additional people at the table.
Agreed. Yeah. I like both. I do mostly solo mediation in the private sector, but that's just because of the way it has been set up in the parties. I think I've done 1 or 2 co-mediations in the private sector, and of course the co-mediations here at the center. And one of the things that I do in those 2 instances where I did it in the private sector, I already knew the other person, and we had a chance to talk beforehand still about styles and how we were going to actually have it go, who was going to take the lead. Even though you're co-mediating, I find that there is still always one person who is leading it, which I think is good, because then the other person can be the supplemental and be there to add stuff that somebody's forgotten, which happens. So what I do generally, if I get a case from the center, I have been known to, and I usually do, say, can you give the other person my telephone number and ask him or ask her if she wants to call me. We can talk about it a little bit beforehand, we don't know anything about the case. But just to get a sense for who that person is, what his style is, how it differs from mine, and then just not to be there at the beginning of the mediation and we're trying to figure out who does what. Like to always have the parties feel like at least, we're there together and we know the procedure and they're comfortable with that. The other thing that I thought about in the last couple of years that is helpful with a co-mediator is when you're dealing with issues that maybe you haven't thought about before that have the possibility of implicit bias coming up, you can't always see that. And the other person possibly can if they're looking and listening, and they might see how you interact with that person or the other person. And then when you have your chance, they've gone out of the room either after one caucus and before you go into the second one, you have a chance to talk with each other and say, how about this? What about this? Did you see this? And I think the same thing, Juliet, that what you're saying is you have a chance to say, well, what we really meant, but you can say that to the other person and have him or her, have myself, check to see if there are some biases that I'm not even thinking about what this other person saw. I was focusing on that person. I really didn't give credence to what she was saying or to what he was saying because it looked like I already had my mind made up about something. So I think that that's helpful too with co-mediation.
I'd like to add one more thing too. Those of you who may regard attorney mediators as kind of a separate species, really what sets us apart, I think, to the extent that we are, is the training that we've received in how we think about things. Because when you go to law school, it's actually almost, the training that you're offered is, they call it inductive reasoning. And don't ask me to explain it, I still can't. But it actually, there's a parallel to how you think scientifically. I mean, that is actually what they teach you. And so a person who's been an attorney for a long time, maybe even not for a long time, but there's a kind of organization that happens with your thinking that's very deductive or inductive, and there's a lot of, you get from point A to point B. It's really nice to have a co-mediator who is not a lawyer mediator, because especially people who are from the social science backgrounds, who tend to be the other largest group that are represented in mediator circles, they have a whole different point of view, and there are things that they're going to see and touch on that really round things out. Phyllis isn't here today, but she stands out as having, I was joking about me being brilliant, but Phyllis and I were co-mediating, and we had a particularly difficult plaintiff. He was there with his wife, and his wife was doing her very best to control him because he was absolutely uncontrollable. I think that's how she spent her life. But oddly enough, what got him excited was being able to talk about sports. And fortunately, I had watched the same game he had, and so we were off to a roaring start. But in the midst of all that, I know that Phyllis was thinking to herself, where is this going? Because she was not a sports person. But then she hit on something else that he was saying, and she saw it, and she kind of, I don't want to say reeled him in exactly, but it was beautiful, it was brilliant, and I was in awe. I would not have seen it. Not my sports persona, not my lawyer persona. I wish I could tell you what it was, but it was just brilliant. And it was something that, because she was an intuitive person and she thinks the way that people in the social sciences think, she saw it, she grabbed hold of it. It was a very successful mediation.
Anyone else? Phil or
I
Tom?
must have gone to law school in the dark ages because they never taught us how to think.
Well, the thing that
I explained it all.
But it was, it was studying cases. It's called the case system.
Yeah.
You learn by reading and discussing actual cases
Right.
and the reports on them. So the other thing, just as an aside, I make it a practice never to let it be known that I'm a lawyer, that I've ever been to law school, because some parties then look to you, maybe even try to triangulate you, thinking, okay, I'm going to appeal to this attorney, because I know how they think. And when comes to me, they can never figure that out. No, it's,
I take the opposite perspective than Tom. I tell him off the bat, I am an attorney, I have been an attorney, and I will not be giving legal advice. I simply say, don't ask me because I'm not going to do it. And if they play me, I guess they play me. You know?
I find the most difficult time is when you have one party who's represented by an attorney and the other party is not, and then the other party who is not, no matter how many times you say that I'm not representing you, I'm not representing you, there's still that tendency to feel like, but, you know, you kind of are, right? Or you kind of will, or you sympathize with me, so you do have to say it and say it again and make sure that you're showing it.
we had an interesting experiment, I thought it was interesting, in Cincinnati called collaborative law, where the parties are represented by attorneys, but they enter into a contract at the beginning that they're there to help resolve this difference, and they're not going to go to court. And if at any time they decide, I want to go to court, that's fine. But they can't use either one of these attorneys. The attorneys are excused from the case. It kind of helped to have the attorneys on that leash, you know, that if they start acting too lawyer-like or too adversarial, that may be the end of the case, and then this client's not going to be very happy.
I'm going to jump in and transition to the last segment for the day because in the interest of time, it's getting close to 1 o'clock. And I want to open it up to questions from the rest of us here for any panel member or all of them, however you'd like to address it. So do you have a question or should we?
I do.
Yeah.
So,
sure, Shannon.
To the panel, because I think it's been touched on by many people, with your in-depth knowledge of the legal process and the system, and say you're mediating a case where you perceive essentially things about how you think it's going to end up if, say, you're not successful finding a resolution. So if you say, I feel, for example, that maybe a jury is not going, this person's not going to play well in front of a jury, things like that, or legally they don't have much that's going to carry them, things like that, where you're almost predicting that it's maybe going to be a poor outcome for one party. How do you integrate that into your process in the moment so that you're not maybe steering the mediation to either help that party not go off a cliff, or how do you stay true to the process of essentially you're there to let those people sort it out, but you kind of have a sense that if you don't succeed here, one person's going to end up driving off a cliff because their case is weak, or
Ask them what they think's going to happen. I don't volunteer what I think's going to happen because I don't know.
yeah.
I don't know how Judge Widgeon would decide a case. I don't know how my sister, Judge Schaedler, would decide a case. I ask them what they think will happen. And there's that, the BATNA system that you are trained in, and that, that's a way to broach that question with them. Is there ever any, are you asking, is there ever any arm twisting? Sure there is. Not, some people do it more than others. It's pretty rare to encounter a mediator who doesn't make an effort to influence a party's decision where they think perhaps that party hasn't fully considered all of the alternatives that are available to them. But I try not to be very directive.
I think it's a dilemma sometimes, and I get caught in it sometimes, where I think a party, particularly in domestic relations, is about to enter into an agreement that probably the judge would never approve. So I think, are they aware of that? Should I jump in and say, just a minute, this is not just, you know? So, and I sat down with Zena Zameda about my dilemma one time. She said, you're not there to arrive at a just conclusion. It's the party's decision. If it happens to be a decision that's not, quote, fair in your opinion, that's their decision. As long as you think that they've had, let it go with that. And that's hard to do sometimes, but sometimes I've had cases in divorce cases where a wife particularly will accept a settlement that I don't think is fair. But if you ever talk to them afterwards, she said, I'm buying peace. I've got to raise these kids. Yes, this may be a lousy, deal for me, but I've got to keep him involved with the family. If I really strike a hard bargain, I'm going to have to live with that for 15 years.
I guess I'd like to address it too, and I would say it depends on the circumstances. If I, as a mediator, if my services are being sought out privately, and they have been, say for example in a domestic relations case, and I have privately mediated both civil and domestic, the attorneys are looking for my expertise as much as for any other reason. And again, bear in mind that when you've got a paid mediator and you've got 2 paid attorneys, there's a lot of money going out there. You don't want to play around with something that is not going to really hold up. So there is going to be some open discussion about likelihoods, and especially given my background when I worked for 10 years for Judge Wheeler and was very familiar with the proclivities of the other judges in the Washington court, that matters. It does matter, because one thing, again, when people are paying for getting a professional job done, you have to take that into account. It's a whole different story in a small claims case when you're mediating for the Dispute Resolution Center. And I will tell you, there are times when I am quite sure I know what's going to happen, but there are many times that I'm not sure. And in the end, again, you have to think about what it's costing people to be there. A lot of times people, the longer they're involved in this process, even if it's less painful than full-fledged litigation, mainly they want to go home and go back to work and start earning money again. So it isn't necessarily terribly useful to tell people what you think your outcome is. I think it is important sometimes to drop a hint to somebody who might be a little bit too starry-eyed about how the judge is going to hear them and grant them the whole world, but sometimes that's what they want anyhow. They don't care if they walk away from a judge's decision with nothing. They just want to have their moment in court. And nothing I say is going to get in the way of that. I do want to add a caveat, though, because I've seen it from all angles. In the early days of the Dispute Resolution Center's involvement in domestic relations mediation, I don't know if they still do this, but that hands-off approach wasn't always helpful because people would put a lot of effort into coming up with an agreement that in fact it might not be a problem with the judge. It might not have actually gotten to the judge because the friend of the court would say, that child support arrangement is against the law and we're not going to sign off of it. So part of what we were trying to communicate to the DRC back in the early days is don't let people walk out with a happy, no child support to be paid, even when it clearly violates the law. Don't let people think they've negotiated a settlement that isn't going to work, because that sets them back too when they're not successful. So it depends.
I wasn't here in the early days.
No.
Yes, you were.
No, I wasn't.
Phil, I was thinking of your role.
Well, it depends on how you define the early days.
And the number of cases I had that are, quote, kind of medical malpractice, where if the doctor or the caregiver had ever said, I'm sorry.
Yes.
That's all they wanted to hear. And I think that it's changed, at least at the U of M hospitals,
Oh, yeah.
now, where there's a, go ahead.
The skepticism that surrounds that concept is overwhelming. If you said, and this is historical, so, and it happened more times than I care, that overwhelmingly, and I'm sure you've heard the same thing, you hear from the injured patient, If someone had just said, we're really sorry that this happened to you, and this is what we've done about it, and this is, what we expect to continue doing about it. Well, back in the day, the response from the doctor to all I ever wanted was somebody to tell me, I'm sorry, it's not about the money, was, it was an expletive for sure. We find, however, now, and since you brought it up, that it's really true. It really works. The concept of acknowledgement and apology goes way beyond where we thought it did. It's resulted in reduced incidence of claims. It's reduced the severity of those claims. It's reduced the cost of resolving those claims. Now, as if Mr. Boothman were here, he would tell you that in order to do it, you have to be prepared to go to trial. You have to be prepared to defend zealously when you're right, when there is no liability. But it works. It's worked here, and it's worked in every place that they've implemented it sincerely. People try to do it halfway. It doesn't work for them. But the guy we're talking about is a fellow named Rick Boothman, who now retired from the University of Michigan. Phenomenal success with that concept of acknowledgement and apology. And, that's, in your training, you probably were told about what a sincere apology looks like. Gee, I'm sorry you feel that way. Doesn't cut it, That's not what that is. And that's why it's so difficult to implement. But I just kind of stole your thunder, Tom. I'm sorry.
It works even in small claims court.
Sure does.
I've had people come in who owe money to somebody else, and the other person hasn't paid. And this one particular case, I got the person who's owed the money aside. She said, she's never told me she's sorry. And so I went and talked to the other person. She said, oh, yeah, this is why I haven't paid her. I've been out of work. My child has been sick. I'm really sorry. I feel badly that I haven't paid. Went back in, and the woman said, fine, forget it. Forget the debt. Oh, that's what I want to hear.
Are there any other questions from the floor? Greta, are you thinking about something? I'll ask one if you're... All right, Greta, did you want to ask? Okay, I thought you were thinking about something. Yeah. Oh, okay. Did you have a comment? Yes.
I just was going to comment on the last question that was asked. I think if I can remember as a mediator that it's not really about me, it's about the parties. So when I say it's not about me, everybody likes to win. You like to come out with a settlement. You like to see that you've done your job in helping the parties get together, but sometimes, for whatever reason, that's not going to happen. Sometimes it's not going to happen because maybe one of the parties wasn't really sincere about being ready to work toward a settlement. This happens sometimes with attorneys on both sides where they really are coming into the mediation for something else, to try to get some advantage for later on or whatever. And sometimes it happens with parties when there is not an attorney. I think we saw something happen recently like that, and the one side just wasn't really going to negotiate at all, even though he said that he was going to when we first went through that, are you ready to, in good faith, mediate? But the other thing is, I've had situations where the one party was not represented, the other party was either represented or was an attorney representing the other side, say the employer in an employment mediation. And so the party not represented was a little tentative and well, okay, yeah, maybe I'll go for this. And of course you get the question, is that what you would do? Do you think I should do this? And you can't answer that question for them, but you can say a second time or a third time, so is this what you want to do? Do you have any questions that maybe I can answer? I might not be able to answer the questions that you ask, especially if it's going to be, should I do this? But do you have any questions about what this means or what this might mean or whatever? And you get a chance to do a little bit more reality testing right then. But sometimes you end up and that party says, okay. And you know, because you've been in caucus with the other side, that that party could have pushed for more. But it's not my job to make sure that the party pushes for all that he or she can get. And some of those employment situations have felt a little bad for me because I knew that the other side, the employer, had more that he could or it could have given had this side pushed a little more. But it kind of reminds me of when I was on the bench and I would be handling a case, a bench trial, and the prosecutor hadn't proven their case. And it seemed like a lot of things were pointing toward the defendant's guilt. But if the prosecutor hadn't proved it, I couldn't get off the bench and say, well, you know, everything points to this person being guilty. Well, not if the prosecutor didn't put it in. So those are unsatisfying moments, maybe, or non-satisfying, I think unsatisfying. But that is, again, it's not about me, it's the process, and that's what you're trying to protect.
Jim Sheridan used to come down off the bench and do that.
Did he?
Might as well have had two prosecutors, but that's a different story.
Any other questions from anyone? Any thoughts, comments?
What were the two questions that we were asked to begin with?
I have them written down. So, and I think we've touched on them. How do you resist explaining the legalities of a case, and then how do you separate your role in advocacy? I'd like to pose a question as well. Each of you have talked about the cost or touched on the cost of litigation, all the people that are involved in a court case, just the staff of the court, in addition to the cost of the attorneys and maybe other additional costs for that. So I'm assuming that these costs would reduce a person's access to that dispute resolution forum. And so do we think that mediation has changed that? The offering of it, having a center, private mediators, that is our system of dispute, our preferred system of dispute resolution, but are we increasing the ability for people to access a system of dispute resolution and to avoid the cost of litigation?
Your question is, do the centers do that?
Just collectively, in this work of ADR, we've heard about mediation, arbitration, negotiation, private mediation, a community center, and we still have courts. So what is shifting, if anything?
I think it has. I think there are a lot of people who don't go to court because they can't afford it. Mm-hmm. And so they may be looking for something else. There's just a case that Greg and I were talking about where this case is coming to the DRC. And I know it's because they're aware of the DRC and they're aware of this alternative. That,
okay.
Would they have...
You made a referral?
Well,
It's a...
I think Tom's
Yes,
right.
it's a referral.
A referral? Oh, thank you.
No, I was talking to... No, was I talking to you, Greg, about it? No, I was talking with Miles about it.
Oh, okay.
Yeah.
The alternative dispute resolution section of the state bar several years ago began an initiative called Michigan Mediates, the goal of which was to educate the public about the availability of these informal processes and to encourage early stage intervention. So yeah, I think so. I think we've done we can always do better, but it has, I think, given people the opportunity to look at different approaches to conflict resolution and
I don't know how if you get statistics from the court on how many cases are pro se. I mean, where people come into court and don't have an attorney. There are some jurisdictions where there are far more pro se cases than there are cases where both sides are represented by an attorney.
I've heard there is an increase for Washtenaw County, but I don't have a
Yeah, and
concrete number.
I wonder if it has anything to do with the fact that there are fewer cases filed now in courts.
We do know that there are fewer
We feel the
filings.
effect of that at the DRC.
I
Absolutely.
do think that the option of mediation has reduced litigation costs because it short circuits the tendency for a case to go on and on and on. And whether or not an attorney actually gets every penny that he or she bills for over time, because oftentimes people just run out of money, it does make it more efficient. Certainly when Judge Wheeler instituted the standing order to mediate, there was a lot of noise that just stopped. A lot of motions that were deflected, a lot of standing orders that or a lot of ex parte orders that people were routinely filing that stopped getting filed. And I do think also, I talked to Walter Hamilton, who's one of the attorneys who regularly practices business law, and he regularly brings cases in front of Judge Brown in the business law dispute matter. And he said we were actually discussing whether or not the option of mediation made it less likely that a case would be filed. And he said, in his experience, really not so much. You could offer somebody with whom you were about to enter into litigation the option of mediating beforehand. He said, but really, it isn't until the case is filed that there's a gun to their head and they have to mediate. But he said, because of this order, from the state, that the business law court is going to routinely make the majority of these cases mediate, said they come to an end a lot sooner, and more issues are worked out before they get to trial, if in fact they could go to trial. So I think it has had a very
Yes,
beneficial effect on the cost.
Good.
Kind of a question related to that point. So cases that are in the process of headed to trial and they go to like a facilitative mediation or evaluative mediation, those are terms I've heard. Is that process a twist on what you do? In other words, at the end of that, are you recommending like a settlement amount based on the strength of each case, or is that something that you have experienced?
Insurance companies, particularly property and casualty carriers, have used a system of evaluative mediation for years and years and years and years and years. And the idea was, now it almost never happens before litigation is initiated. But the idea was that there had to be a system to draw the line in the sand, so to speak, and have the plaintiff say what it was they were willing to take, or the plaintiff's attorney what he was willing to recommend to his client, and have the defense attorney say what it was he was willing to recommend to his client. And if it was done artfully, many times it resulted in a settlement. If it's not, then all it does is create lines in the sand. So it's there. That's evaluative. In commercial cases, we're talking about more often than not, we're talking about money. Money tends to be an impersonal kind of thing. Many times what you see in the small claims court is it's about money. That's the proverbial principle of the thing, and that's why small claims cases are interesting and fun, because the dynamics, the philosophical, the psychological dynamics of them are so different than when you're talking about hundreds of millions of dollars and people just want to get the heck out of here.
We're going to have to stop here because the other group is ready to come into the room. But thank everyone for the discussion. And Sally, did you have any closing remarks?
Our March meeting will be March 6th, a month from today, and Brenda's going to speak, and
I thought we did.
Oh, Bern Dempsey from the Wayne Mediation Center. He's going to be here to do a presentation. He's been digging into the parallels of mediation in civil rights activists like Martin Luther King and Chavez, Cesar Chavez. So he wants to share his understanding and findings about that with us. And I think it's going to be an interesting discussion, if nothing else. So, yep.
Thank you all.
Thank you.